Hello and welcome to FFRF's Ask an Atheist. I'm Sammi Lawrence, a legal fellow here at FFRF. Yesterday, the Supreme Court heard oral arguments in a major case that deals with the FDA's regulation of mifepristone, a medication used in the majority of medication abortions here in America. Backed by a religious organization, several groups sued the FDA to try to restrict Americans' access to mifepristone. Today's show is titled, Dr. Alito, What Pills Can I Take? We're here to break down the court's arguments for you. I'm joined remotely by FFRF attorneys Liz Cavell and Patrick Elliott.
Nice to join you.
Hi, as always, we want to hear what you are thinking about this subject. So please leave your questions in the Facebook comments below, or you can email them to askanatheist@ffrf.org. Patrick, do your usual thing and give us some background on this case.
Yeah, there's a lot going on, so I'll try to hit the main points, and you both can obviously add to that if we need to. So this case started with the Alliance Defending Freedom, which is a Christian legal organization. They filed suit against the Food and Drug Administration in order to block the use of mifepristone nationwide. And then their plaintiffs in the case include several medical organizations. Some of them were newly created, probably for this lawsuit, that oppose abortion. And they claim that their members have a right of conscience not to take any action that makes them complicit in abortion. So they filed this case in a one-judge district in Texas to have it heard by a specific judge, a Trump appointee and religious person, Matthew Kacsmaryk. And last year on Good Friday, he issued a broad order against the FDA's approval of mifepristone, which was originally done in the year 2000. And then he also issued an order against some of the other actions by the FDA, which were in 2016 and 2021, that allowed mifepristone to be used more widely. That includes through 10 weeks of gestation, consultation through telemedicine with a doctor, and then allowing for mail order shipments. The FDA and then the actual drug manufacturer, Danco Laboratories, filed an appeal to the Fifth Circuit. The Fifth Circuit ruled that the drug couldn't be totally banned because the plaintiffs had waited too long. Obviously, they had waited more than 20 years to sue. But the Fifth Circuit upheld some of the other restrictions. So they upheld the preliminary ruling against the 2016 and 2021 expansion by the FDA. At that point, the U.S. Supreme Court really had to take some action to intervene. They issued a temporary stay while the court was going to decide the case and decide these issues. And the arguments that we heard yesterday really concerned two primary issues, which is, do these organizations, which include some individual doctors who work in emergency rooms, do they have legal standing to bring this type of lawsuit, is the first question. And if they answer the first question, that they do have standing, then the second question is, were the FDA's decisions regarding mifepristone, were those arbitrary and capricious? So that's kind of the two issues that the court took up yesterday.
Before we get into some of the clips from the argument, Liz, can you briefly address the theme and title of today's show, Dr. Alito, What Pills Can I Take?
Yes, so it's funny, but it's not funny because it is so important to point out how absurd this challenge actually is, that we are here discussing whether judges should overturn the evidence-based medical decisions of the FDA because of the religious objections of these anti-abortion individuals who are pursuing this litigation just on a mission and with the crusade of making abortion, all types of abortion, unavailable. So Justice Alito just authored the opinion in 2022 that overturned Roe versus Wade. And here we are already one step closer to Alito and other justices deciding what medications people can use for abortion, contraception, or any other medical issue that they disagree with.
Yeah, it's definitely insane that we find ourselves here less than 2 years later. Now, we'll get into some of Alito's questions for the attorneys during oral argument. Let's start off with the arguments for the two attorneys who are actually defending the FDA. We have some clips of exchanges with them and the justices. On the side of the government is Elizabeth Prelogger, the Solicitor General for the U.S., and representing the drug manufacturer Danco Laboratories, we have Jessica Ellsworth. Let's listen to a clip of Solicitor General Prelogger's opening statement.
FDA approved mifepristone based on the agency's scientific judgment that the drug is safe and effective. It's maintained that judgment across 5 presidential administrations, and millions of Americans have used mifepristone to safely end their pregnancies. Respondents may not agree with that choice, but that doesn't give them Article III standing or a legal basis to upend the regulatory scheme. At the outset, respondents lack standing. They now concede they can't rely on a statistical theory of injury like the lower courts did. Instead, they have to identify a specific doctor who faces imminent harm. But their theories rest on a long chain of remote contingencies. Only an exceptionally small number of women suffer the kind of serious complications that could trigger any need for emergency treatment. It's speculative that any of those women would seek care from the 2 specific doctors who asserted conscience injuries. And even if that happened, federal conscience protections would guard against the injury the doctors face. And there's no basis to conclude that any of that would be traceable to the incremental changes that FDA made in 2016 and 2021, as opposed to the availability of mifepristone in general.
So the Solicitor General is laying out not just the facts of the case, but the facts of the plaintiffs and who they are and how, or in this case, how not, they are injured by the FDA action that they're actually challenging. And, we'll talk in a minute about this, but one of the big points of argument in this case is whether or not the plaintiffs should actually even have been allowed or be allowed to bring this challenge because of how remote and speculative the injury that they're claiming is from the FDA's actual action. And I think, again, as it's really important not to lose sight of the absurdity of the case, this is something that I think most of us would have considered, because we're not favored Christian nationalist plaintiffs, like bordering on frivolous in terms of the argument being made for why these plaintiffs should even be permitted to bring this challenge.
Yeah, definitely. As Solicitor General Prelogger alluded to, this ruling by the FDA, mifepristone, has been approved for over 2 decades now, and suddenly these organizations and doctors are able to challenge it ostensibly because maybe someday a woman might take mifepristone and she might suffer some kind of side effect from it that might cause her to choose to go to an emergency room where maybe one of these doctors is working, and this doctor might be the only doctor there, and they might be forced somehow to operate on this woman or be complicit in something, maybe.
Yeah,
Exactly.
I think the briefing gets into more of those maybes too, and this came up at the argument. I don't think we have a clip, but I was interested to hear, and I think it was Justice Jackson asking, is like some of these doctors that the plaintiff groups are pointing to are operating in states that this is not legal to do. So, if you have a doctor in Texas where, that doctor can't prescribe mifepristone to the state, how are we even getting more convoluted to saying, how does this doctor have standing when that medication, a patient couldn't actually legally get that in Texas right now? They'd have to go out of state to do it. So I thought that the chain of, what the courts call the speculative chain of events is just off the wall that I think, as Liz, as you mentioned, like we could never get away with this on like one of our cases for establishment clause or something is coming up. What they've done, and so obvious to us, is it's been reverse engineered of, hey, we don't like that this is happening. How could we possibly find someone who could legally challenge it? And they think they've figured that out. I think the Supreme Court's probably going to, maybe going to disagree with them on that. But to me, it's just so blatantly obvious of the reverse engineering, and then you still have this crazy chain of events. But I want to get both your reaction to, we heard, Prelogger's opening, kind of your reaction to her argument overall, and just kind of the government and Danco's arguments. How did they do, and kind of what you thought?
I was not surprised, but I guess relieved. that so much forceful argument and time was put towards arguing hard on the absurdity and frivolity of this and the lack of standing in this case. So I think both the Solicitor General and Danco spent a lot of their time arguing the point of this case shouldn't even be heard by the court. And these plaintiffs have put forth such a frivolous, attenuated theory of injury, and compared to what they're asking for and what they got in terms of relief, which is basically taking mifepristone off the shelves and undoing its FDA approval, that there's just a major problem with how these plaintiffs are trying to use the courts to achieve these extreme ends.
Yeah, definitely. I felt that the argument on the side of the FDA and Danco was very strong. I also like that Solicitor General Prelogger especially repeatedly hammered home the statistical reliability of the FDA's conclusions and their expertise, and that ultimately this is a court of armchair doctors attempting to second-guess decades of research done by some of the top medical professionals in our country.
Yes, pointing out flat out, I don't remember the exact words, but, no one on the court is a statistician. No one on the court is a data scientist or any kind of scientist. That the courts are just absolutely ill-equipped to second-guess decades of data and evidence-based decision making on the safety and efficacy of pharmaceuticals being done by the FDA.
It reminded me a little bit, Liz, your point there, this comes up in our cases, is judges are good at interpreting law and kind of understanding how our judiciary works and how legal frameworks impact people. They're not good at decide medical determinations. They're not good at historians. I think that's one of the things that comes up in our cases is the justices put on their history cap, and then of course, like we saw in the decision overturning Roe versus Wade, the Dobbs decision, let's pick and choose some historical things, and then you have actual historians pulling their hair out because they're like, wait, these judges don't get any of this. That's not how we do things. We don't just go back and cherry pick what supports our point, which it just made me more acceptable in areas of law that we work in. So it had a lot of parallels to me of that. Is like, there are things that judges shouldn't be deciding. There's a reason we have a federal agency that makes these determinations. Let's let them make that determination and not have a one judge district in Texas decide this and overturn their reasoned decision making.
Totally. And this is why, it is not hysterical or out of line to say and to point out how extreme this court is in terms of abusing its power, overstepping its authority in, playing the historian and, the statistician and the medical doctor in all these cases where it really doesn't. It's not appropriate. It's ill-equipped to do it, and it's not required. It's so patently obvious to just look at the record in this case. The scientific community, as the FDA has obviously noted in its approval of this drug for over decades, it's safe and it's effective. And doctors have concluded this, and scientists have concluded this, and that's the end. We don't need these 9 random people to just, put on their medical hats and say, hang on a second, what do I think? I mean, you don't need to do that in order to analyze the legal questions here, even if this were a valid and non-frivolous claim.
And as we've discussed, standing came up multiple times throughout the argument, and FFRF had actually filed an amicus brief in this case in which we partially argued the standing issues. Did you want to mention anything more about that, Patrick?
Yeah, you and I had worked on this obviously with American Atheist filing a brief, and that's what we talked about was the standing problems, because that's not how the court normally addresses things and just says, we have a quote from our case, U.S. citizens have innumerable religious beliefs or moral viewpoints concerning almost all controversial topics, including abortion. A key question in this case is whether a special subset of religious individuals will be permitted to use the courts to restrict other citizens' rights and actions. I think that kind of sums it up with also what we saw with how the courts were talking about it. I think some of the justices even some of the conservative justices, I think being a little questioning of whether these plaintiffs can actually take this type of case. And so, they were talking about it, but one of the disturbing pieces was maybe they agree that the FDA could win this case, but then they want to go somewhere else. And so the justices at points were talking about associational standing or things that might bleed into a lot of other types of litigation. And one of those was Justice Gorsuch was asking about standing in cases like ours, like Establishment Clause. And so I think we have a clip of Gorsuch asking about the Establishment Clause.
I've heard and listened to your argument and read the briefs, and I think I understand it. But how does it fit in your mind with offended observers standing under the Establishment Clause or some injuries about I access a park and I like to look at it in a certain way, and those kinds of injuries that the court has sometimes recognized and other times cast doubt on?
That wasn't the first time I threw my stress ball across the room, but it was one of the times.
I was just going to say we cut off the answer because it kind of gets long, but I think the answer was fine. But really, we wanted to highlight, how the justices are looking at this case as a vehicle to do something else, like that issue of Establishment Clause, or whether environmental groups can challenge damage to public lands has nothing to do with this case. But some of the justices, like Gorsuch, I think wanted to put that in, and maybe they have a little bit of a ticking time bomb in a concurrence or something that they're looking at. Gorsuch seems very much against the idea of associational standing. So a group like the Freedom from Religion Foundation, can it sue on behalf of its members? Even when in our cases, we would be pointing to a very specific person and saying, this person who lives here experienced this from the government. We're just kind of the conduit. He seems to not like that idea at all and was kind of using this opportunity. So I don't know if you all saw other, I'm calling them ticking time bombs, but they may end up in an opinion, have nothing to do with this case, but they want it to come out in some other case is kind of what it looks like. Oh,
there's plenty of ticking time bombs, landmines, things to talk about. I just wanted to say on the Gorsuch quote his whole little analogy on Establishment Clause standing, that was so infuriating coming from him because, of course, his point is he hates Establishment Clause standing and thinks that nobody should have standing to challenge anything that violates the Establishment Clause. And it is so twisted to say, or it's just so manipulative to use this case to inject that so that he can later say in his concurring opinion, yeah, the plaintiffs here don't have standing in this frivolous lawsuit that has absolutely no connection between injury and relief. This is just like all those establishment cases, and we need to just, throw out all this offended observer standing altogether. And, it applies to this mifepristone case too. So look at how reasonable and even-handed I am.
Yeah, definitely. And I think it's important to note for anyone at home who's not aware, the court has really essentially decimated standing for Establishment Clause claims over the last several decades. We're at FFRF and other organizations like this, we're really working with just the bare minimum legally at this point to try to bring cases in court, unfortunately. So justices like Gorsuch signaling that they further want to just do away with any hope of getting Establishment Clause cases into the courthouse is really very concerning.
And it's a little troubling. He's already lost that argument. There was a case, the American Humanist Association case over the Bladensburg Cross, and by 7 justices to 2, they said, yes, these plaintiffs can challenge this giant 40-foot cross on public property, but by the way, we don't think it's unconstitutional. And I think it was just Gorsuch and Thomas kind of writing a concurring opinion saying, well, we don't think they can even challenge it. Well, you've lost that. 7 justices disagree with you on it. It's kind of odd to bring up here, other than I think the point Liz is kind of making is trying to play, I've been consistent. My bigger fear is what happened with the Voting Rights Act, because I think it was Gorsuch and Thomas said a number of years ago, hey, we don't think private litigants can take cases under the Voting Rights Act. And then that's a signal. They put out the bat signal to the lower courts to say, kick out these other cases that are going to come up. And so that's I think it's not just us. I'm reading a little bit of commentary this morning. Other people are saying, hey, there's some bat signal going out here on some of these issues.
For sure. Well, on other time bombs in the opinion, I have to say it while we're talking about this case and oral arguments. I know it's a little bit of an aside and isn't going to get covered as much because it doesn't relate to standing. But I was very troubled at how incessantly Justices Thomas and Alito questioned the attorneys for both sides on the Comstock Act, which, if you haven't been following, is like a 1875 law on the books. That's, basically dead letter law. It's not been enforced because it outlaws obscene material from being, I think, shipped across state lines or, disseminated by common carriers. And there's more than just a little bit of illusion from Justices Thomas and Alito that potentially future law enforcement officials, like future DOJs and such, could actually enforce that law because it's still on the books. And shouldn't that have been part of both, I guess, the FDA's analysis of approval of this drug and how do the parties, especially I think Thomas tried to say that Danco, the private drug manufacturer, how do they reckon with the fact that this law is on the books and I guess accepting the premise that abortion pills are obscene materials? Aren't they violating the Comstock Act? That was extremely scary. Nobody wants that. And I think those two justices spent a very surprising amount of time asking questions about it.
Yeah, definitely. That's very concerning, especially since, they're being disingenuous when they asked Solicitor General Prelogger, the Comstock Act, this is significant, the FDA should consider it. The federal government has very clearly not been enforcing the Comstock Act at all since the 1970s, and it wasn't necessarily that well enforced prior to that. Federal case law from Circuit Court of Appeals, I believe the Sixth Circuit, if I'm remembering correctly, even acknowledges that the Comstock Act has essentially been dormant and the federal government has simply not enforced it. The FDA is the federal government, so I think if the FDA thinks that the federal government isn't enforcing the Comstock Act, it's not required to be considering it when it is the government.
The thought process is just bizarre, is that this agency must restrict something. It's weird to say that I can sue because they're permitting something. That's where we're at. That's why it's so bizarre. And their actual mandate is to just make determinations is this safe and effective? So it'd be bizarre for them to look at other areas of law that they don't have authority over to say, okay, we're now going to make decisions not based on whether something's safe and effective, but whether we think this should or shouldn't be, we think people should or shouldn't, do a particular action. It's not something they do. So it's just weird. I don't even have good analogies to say suing an agency because they're not banning activity that you think should be banned. That's where we're at right now.
Yeah. And that's my point. It's that line of questioning being relevant to the case before the court is so tortured. There is just no world where that law is before the court, let alone the tortured analysis of why it's relevant to the FDA's approval process for this drug. And so the fact that those two justices devoted so much airtime to signaling that view that isn't mifepristone actually illegal under the Comstock Act, and isn't the Comstock Act still good law that everyone should take into account, is really significant, right? They're signaling their belief, and it is just, and the Comstock Act, talk about theocratic lawmaking, is just a, moralistic law that outlaws things that some people find objectionable. And of course, we're talking about moral judgments, personal moral judgments. And I think the original purposes of the law had to do with banning contraception or making contraception and probably porn hard to access.
Yeah, exactly. And that really goes along with the theme throughout the argument of justices just second-guessing the FDA and second-guessing experts and what the federal government is even saying about other branches of the federal government. We have a clip of Alito, for example, just asking if the FDA is infallible.
During the questioning of the Solicitor General, the statement was made that no court has ever previously second-guessed the FDA's judgment about access to a drug, right? And it's never second-guessed that.
Oh. You mean Dr. Alito? Is that who we're talking about?
Yes.
You called him Justice.
Yeah. We all agreed that that portrait pic of Alito is way too friendly and does not adequately capture the menace that he presents to all of our individual rights. But he was saying in his little sarcastic way, so if you're saying the court has never second-guessed ever in the history of the court the FDA's determinations on safety and efficacy, does that mean the FDA is infallible? That's a real gotcha question from Dr. Alito. But I mean, the point is not is the FDA infallible, as Justice Alito well knows. The legal question is the FDA's decisions in regard to or with respect to this specific drug, decisions about approval, were they arbitrary and capricious? That's a high standard of legal judgment, as it should be, because, again, the FDA is the agency, the branch of government that is staffed with the experts who can actually make these determinations. Justice Alito, of course, is distracting from that by, just saying, is the FDA infallible? I mean, what, we can't second guess the doctors?
He had asked a lot of questions with, I think, this very, and we've heard it in so many of the cases that touch on religion or on abortion, a very angry tone and kind of disrespect towards the Solicitor General or whoever might be arguing. So I think that wasn't an out of context clip at all. He probably asked, as many questions as any justice over this 1.5 hour period, and so we've kind of selected that one to show, that kind of tone. I think he's probably the most extreme on this case. When you listen, is like he's willing to fully say, yeah, the FDA made an arbitrary decision here, and I don't even think Justice Thomas would maybe decide that. So he may be alone in that decision. But it was very much an aggressive questioning by Alito throughout the whole argument, I would say.
Yeah, and again, that portion we just played is questioning on the actual merits of the case. We talked so much about standing, and a lot of time in argument was devoted to arguing over the question of whether the plaintiffs have standing in the first place. But the justices did address, and Justice Alito was specifically very eager to address the merits of the case, which is whether the FDA acted, arbitrary and capriciously in approving and expanding, actually not approving, in expanding access to mifepristone after 20 years of safety data. And it's astonishing to see how willing, because, right, of course, I think Patrick's right. He would probably find for the plaintiffs on the merits. And when you sit back and think like, oh, that means he also has to find that this frivolous absurdity of a lawsuit is properly before the courts, it just goes to show you how extreme and how much of an activist he really is.
Yeah, exactly. And Justice Ketanji Brown Jackson really did a good job in the latter portion of the argument, I think, bringing it back to standing and what the issue really is. And Justice Jackson questioned the doctor's attorney pretty harshly, I think, but but justifiably wanting to know why the organizations and doctors suing couldn't really name even a single doctor who could declare that they had been really, truly, concretely injured by the FDA's regulations. And we have a clip of that.
Counsel, can I ask you about the remedy and sort of the way that I was talking with the SG? I mean, it makes perfect sense for the individual doctors to seek an exemption. But as I understand it, they already have that. And so what they're asking for here is that in order to prevent them from possibly ever having to do these kinds of procedures, everyone else should be prevented from getting access to this medication. So why isn't that plainly overbroad scope of the remedy the end of this case?
So with respect to the premise of that question, Justice Jackson, I don't think our doctors necessarily are able to object for two reasons. One of this is the emergency nature of these procedures. As the FDA acknowledges, many women do go to the emergency room. And if we just think about what that might look like, take Dr. Francis. She's on the labor and delivery floor supervising.
I'm sorry. I don't want to hypothesize. Tell me in her declaration where she talks about not being able to object or pose a conscientious objection.
She talks about, Your Honor, being I
mean, can you point me to any place in the declarations where a declarant states that they attempted to object but were unable to?
No, Your Honor, for two reasons. One, these are emergency situations. Respondent doctors don't necessarily know until they scrub into that operating room whether this may or may not be abortion drug harm. It could be a miscarriage, it could be an ectopic pregnancy, or it could be an elective abortion, Your Honor. In addition, the government simply cannot get its story straight on EMTALA.
So, yeah, I think she
Love
was,
that deflection at the end there.
Yeah, no, just Ketanji Brown Jackson was really, I think, asking some tough questions. And the conscience harm, why that comes up is because there is this federal protection to say if you're a doctor, you have a right of conscience to basically not participate in an abortion if that's your choice. And so despite that protection, these doctors really are what they're after is blocking other people from doing something, right? They want to prevent this drug from being available. They want to prevent women from taking it. They want to prevent other doctors from prescribing it. That's what this is at. And I think the justices, color me impressed that they were very into these. Declaration is basically a sworn statement. So these sworn statements from these plaintiffs or individual members of the plaintiff groups saying things, but I don't think they go all the way. Like they don't say, I had to do this thing before despite raising my conscious, protection to my employer. Like nobody ever said that. And I think Justice Jackson did a great job at, asking about it. And I think even there are points where Amy Coney Barrett asked about it too. I think there are issues with these statements from these doctors that are trying to thread the needle of, oh, well, I don't like this, but I'm somehow going to make it about me. I don't think they get there. And I think the justices, thankfully, I think they see through it, or at least some of them see through it.
I think that was such an important point, and I was so grateful to hear it hammered by Justice Jackson. And just to point out what the answer is from the attorney Hawley, who, of course, works for Alliance Defending Freedom and is representing the plaintiffs in this case. I guess the argument is, no, there's no evidence that individual doctors have ever raised a conscience objection and gotten exempt from participating in a procedure that violates their conscience, because as Patrick just pointed out, that law already exists. Like no doctor has to perform any type of, they are protected by law from having their employer force them against their objections to participate in abortion care. But Hawley is saying, she's answering Justice Jackson's question by saying, well, no, because it comes up in an emergency situation, they don't have the time or the ability or, I don't know, the inclination to raise a conscience objection. So because of that, we have to ban all mifepristone. It's kind of the only way to stop this scenario, this pickle from besetting our plaintiffs, right? Because it would only come up in an emergency situation and they can't be expected to raise their objections before that emergency arises. I mean, you got to take mifepristone off the shelf.
Yeah, and it's just insane. And I think it's important to acknowledge how, you're a doctor who is working in an emergency room, presumably by choice. You've chosen this profession, you've chosen to work at an emergency room, and a woman or person comes in and they're experiencing some serious complications from something like abnormal bleeding, for example, and you're really sitting there concerned not with their life and health and safety, but you're worried, oh, is this related to an abortion or a medication abortion? And how is that going to affect me, as opposed to how is this affecting this person who is possibly dying on a table in front of me?
And I think the fact that there's no evidence of individual doctors having been in that situation speaks so much to the fact that, like, these realities don't exist, right? Either because, Sammi, maybe some doctors, even if they're anti-abortion zealots, aren't thinking about that in an emergency context, or because the protections we have for exemptions for religious actors in all walks of life are already so freaking robust that this situation does not present itself to any doctor.
Right. I think it's made up. I mean, is the and her, if you heard Holly's like situation to get the justices to think about it, it's like that. This is just funny because not that I'm any expert. My wife works in the medical profession as a nurse, but it's like funny the picture she's doing is that the doctor's scrubbing in the ER and has no idea why the patient is there, and they're just going to go in and like this is not how probably any of this operates. I imagine for people in the medical field, like the description of like this scenario is like probably very atypical, and it's like, is this theoretically possible that a doctor might have a patient presenting that they have to do something on? But we have this whole idea of like informed consent. So like presumably patients are communicating what care they need or what their situation is if they're conscious. Like this is so bizarre that's the scenario she immediately goes to respond to a Supreme Court justice's question that we all had to listen to. So just flagging, like, I don't buy the stories that are being told on that side. Like, not, again, me playing lawyer, it's not fair to me to trump the justice playing doctor. Like, I don't think, I think that these scenarios are not real, and that these doctors, if you actually press them, we're going to find out a lot more about what has actually happened to them in the past or what their actual beliefs are. So besides, we're running shorter on time, so I just wanted to ask you both. We've all heard the arguments. Kind of, what's your overall take? Like, who wins this case? What are your thoughts?
I do think it seems likely that the court is going to dispose of the case on some sort of standing basis. They're not going to reach the merits of the case. I think there's a majority that probably wants to avoid deciding the merits of the case at this moment in time. So I do expect some sort of decision on standing. And I think it'll matter a lot what the analysis is there. We talked about Justice Gorsuch alluding to all his creative, consistent theories on standing. And so it could be a broad or a narrow dismissal on standing grounds. And I think that would change the harm. The harm caused by a decision or not caused by a decision could vary a lot. But I don't expect them to reach the merits. But I am still very troubled by the signaling that was made by the ultra-conservative justices on the court during oral arguments. This is not the last this court has heard of abortion access and medication abortion access. And it's just, I think, major proof points of the fact that Dobbs was just the beginning.
Yeah, I tend to agree with Liz's take. I think that they've found themselves in a mess and that they're going to try to find a way out of it that lets them rule for the FDA, hopefully, but doesn't hurt any of their personal interests down the road, and that probably means some kind of standing ruling in this case.
We're all on the same page. That's usually not. Usually I'm the optimist when I shouldn't be, but I think a lot of the reactions are, we're so much focus on standing. It's probably going to be that standing decision before we even get to the merits.
Yeah, I don't know that I don't expect it to be unanimous. I actually do think, at least, we might disagree on this, at least Justices Thomas and Alito would be happy to reach the merits on this case in particular. But it didn't seem like there was a majority for that. But of course, it hinges on some very radical conservative justices' votes, like Brett Kavanaugh, who we didn't really hear from, and Justice Roberts, who is, no friend to the choice movement.
Definitely. Unfortunately, we probably will not get a definitive answer until June of this year, so fingers crossed until then. And now I think we have a little bit of time for some audience questions. I'll just throw this one out there to begin. Do you think that this case will bring more public attention to how far bad faith actors like the ADF are willing to take religious objections? Are there potential consequences to that?
I think that the media or the public is sniffing this out a little bit. Like, we've always had our concerns. And one of the interesting things was not our amicus brief, but there was an amicus brief, I think it was by the ACLU, that highlighted some of the things the doctors in this case have said and some of their research that has now since been rescinded. So I think that this whole thing was built, it was like a house of cards. And I'm hoping that an additional spotlight will actually shine light on it. Because I think the scenarios and the things the doctors are saying should be heavily scrutinized, because I don't buy it on its face. I think we need to look at it. At the stage of the case we're at, we don't really get to do that because they kind of put in their sworn statements and the FDA didn't get to, cross-examine them yet. But I'm hoping that there will be greater scrutiny of what ADF and these other groups are doing.
Agreed.
Another question. Is there a chance that this case will put unintended strain on the court and cause certain judges to act as swing votes more often? I
wrote a blog 2 days ago that was trying to predict this, and I said, I think that certainly the Chief Justice is an actual swing vote, and I had suggested maybe Justice Kavanaugh, but we did not hear from Justice Kavanaugh yesterday on this case, so he may be one of the swing votes. Depending on the issue, possibly even Amy Coney Barrett, depending on what reasoning the court gives. So I don't know that it changes the typical swing vote. I think that this cemented, Alito and Thomas are so far gone, they're just not ever going to probably rule in a way that we would agree with. But so there's only a few people in play there, and it seems like Kavanaugh and the Chief Justice are probably the normal swing votes.
I think this case will have give the court, I think, unfortunately, an opportunity to sort of do one of its famous kind of smoke and mirrors to the public thing, where it looks really moderate on a controversial case, because the absolute astounding insufficiency of the plaintiff's standing in this case might make for a more robust, less swingy majority than usual. But I do think it's so important, and I keep beating this drum with, we heard about the Comstock Act, and I want to point out, even though I think Justice Barrett is a very likely potential dismisser on standing in this case, she did ask a lot of questions, and I think she alluded many times to sort of distinguishing between abortions that involve alive fetuses and non-alive fetuses. In other words, fetal personhood type of language. I mean, I think there were a lot of really troubling lines of thought in the questioning. We focused on Alito and Thomas, and they're so ham-fisted, but this is no moderate, we're just going to return this question to the majority of Americans and their people's representatives. I mean, I don't think there's any kind of swingy type of majority on the court for the general question of choice and reproductive health care access that would align with what the American people think is reasonable.
Hopefully we'll get at least moderate appearing opinion that doesn't burn the house down quite yet. So that we can, live to fight another day and actually have something to keep attempting to hold on to. Thank you for joining me, Patrick and Liz. That concludes Ask an Atheist for this week. Don't forget, we also have a weekly broadcast TV show, Free Thought Matters. This week, Annie Laurie Gaylor and Dan Barker have a conversation with the executive director of the Secular Coalition, Stephen Emert. Here's a preview.
So the Secular Coalition for America was founded over 20 years ago as a lobbying organization, obviously here in Washington, D.C., to support all of the secular, atheist, and humanist organizations that are out there working nationally on other priorities. We now, as I mentioned, have 20 members, including FFRF, but everything from ex-Muslims to Black non-believers to the American Humanist Association, military atheists. And we try to be the voice for all of those disparate organizations in Washington, D.C. And so our lobbying efforts are on behalf of them, their members, their supporters, and all non-religious Americans.
You can see Free Thought Matters on TV stations all across the U.S. and also on FFRF's Facebook and YouTube channels.
And don't miss Free Thought Radio. This week, the show will feature a talk with C.N. Norris, author of the new book, Bodies Under Siege, How the Far-Right Attack on Reproductive Rights Went Global. You can find Free Thought Radio at ffrf.org/radio.
Check out the latest episode of our We Dissent podcast. In our latest episode, we discuss everyone's favorite topic, taxing churches. Listen and subscribe to We Dissent wherever you get podcasts, or check us out online at we-dissent.org.
If you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. If you're a member already, thank you. And if not, please join us. See you next week on FFRF's Ask an Atheist.